Good evening. I hope everyone had an enjoyable family weekend. I'm honored to invite you to the Marion Minor Cook Athenaeum. My name is Wesley Whitaker, and I'm one of your Ath Fellows this year. At the Faith and Freedom Coalition Conference in June 2016, then-candidate Donald Trump held up a list of potential justices, assuring the crowd that they were all pro-life and that with just a few Republican appointments, the Supreme Court would eventually overturn Roe v. Wade. It seems like his strategy worked, with Trump winning 81% of evangelicals. According to exit polls, over 70% of voters viewed Supreme Court nominations as an important factor in choosing their candidate. Nearly 1 in 4 voters viewed the Supreme Court nominations as the most important factor, and Donald Trump won these voters with 56% support compared to 41% for Clinton. During a campaign fueled by populism, judicial appointments provided a key source of unity in an otherwise divided Republican Party. Many of those who took issue with Trump nonetheless voted for him because the individuals appointed to the federal bench are still deciding cases with wide-ranging implications long after the president that appointed them leaves office. Our guest tonight is a veteran of the selection and confirmation of 8 Supreme Court justices, and will discuss how the judicial nomination process shapes our laws and society for decades. Ronald Klain has devoted many years to public service, most recently serving as the White House Ebola Response Coordinator from 2014 to 2015. Before that, Klain served as senior White House aide to President Obama and was responsible for implementing the Recovery Act, and as chief of staff to Vice President Joe Biden from 2009 to 2011. He has also served as chief of staff for Vice President Al Gore, chief of staff and counselor to Attorney General Janet Reno, and staff director of the Senate Democratic Leadership Committee, and chief counsel to the Senate Judiciary Committee. Klain was also associate counsel to President Clinton in charge of judicial selection. He began his legal career as a law clerk to Justice Byron White for the Supreme Court's 1987 to 1988 term. Klain gained national notice as general counsel for the Gore Recount Committee in 2000, recognition which selected him as National Law Journal's Lawyers of the Year and featured in HBO's film Recount. He has worked on 7 presidential campaigns, serving as a top debate preparation advisor to President Obama and candidate Clinton. Klain now serves as executive vice president and general counsel for Revolution LLC, an investment firm launched by AOL co-founder Steve Case in 2005. Klain is magna cum laude graduate of Harvard Law School, where he was an editor of the Harvard Law Review, won the Sears Prize for highest grade point average in 1985, and serves as an Al lecturer in law. He was a summa cum laude graduate of Georgetown University, where he has served since 2011 as an adjunct professor. Mr. Klain is the featured speaker for CMC's 2018 Family Weekend. As always, I must remind you that audio and visual recording are strictly prohibited. Please silence and put away your mobile devices at this time. And please join me in welcoming Ron Klain to the Athenaeum.
Thank you, Wes, for that great introduction. It's great to be here. I'm not sure how the rest of the talk is going to go, but I do know that that was the best meal I've ever had on a college campus. So thank you to the Ath staff for that, for everyone involved in it. Thank you, Priya, for having me here. It's great to be here. I promised my son, Daniel, the sophomore here, that I wouldn't intentionally embarrass him in this talk, unintentionally embarrass him in this talk, but I will say, for his friends in the room, there is an embarrassing photo of Danny in my slides, so when we get to it, you can call that out. With that, last thing I want to say before I get started is this is a topic of interest, I hope, to both lawyers and non-lawyers, to people who are history buffs and people who are just concerned citizens. I've tried to make the talk generally applicable, so for some of you who are real experts in the field, you may find some of it a little common or simple with what you know. Hopefully, we can get into more depth on some of these things in the Q&A if that's where you are. So I want to talk tonight about how the president selects and how the Senate reacts to Supreme Court nominations. And I do think this is an important topic for all of us, not just for lawyers or policy nerds or government nerds, because I think that it obviously, how the Supreme Court is composed, who the members are, how they get there, has a great effect on our Constitution, our rights, and our society. And so hopefully it's something that we all share an interest in. And I want to start with just some of the numbers. Which I want to start with. There we go. That's where I want to start, with some of the numbers. We've been had the Constitution for 229 years. 118 people have served on the Supreme Court. And by comparison, we've had about 2,000 U.S. senators in the same period of time, 12,000 members of Congress. So obviously, this is a pretty small group of people over 229 years. How did they get there? 162 people have been nominated to serve on the Supreme Court, 157 men and 5 women. Now, 37 of them weren't confirmed, were either withdrawn in the process or rejected by the Senate. And so that's almost 1 in 4. It's no slam dunk if you get nominated that you're going to make it to the Supreme Court. Another 7 got confirmed and never took their seats. 2 of those people died after they got confirmed. Those people were super unlucky, I guess. 5 of them got confirmed and turned down the job. You might ask, well, why would someone do that? Well, back in the olden days, the Supreme Court wasn't just the apex of our federal judiciary. It was the entirety of our federal judiciary. Supreme Court justices, when they weren't sitting at the court, got on horses and rode around the country and heard cases all over the country. It was super unpleasant. It was super dangerous. And so 5 people said no once they got confirmed. They didn't want to do that, thanks, but no thanks. For those of you who think about the U.S. Marshals and think about them as like in the wild, wild west coming into town and cleaning things up, their first job, we created the Marshal Service as part of the Judiciary Act of 1789 to protect the justices as they rode around on circuit. And so I think there were at least 5 people early on in our country's history who said, if you need to create the marshals to keep me safe, this is not a job I want. So 7 confirmed, said no, or died. The result, 162 nominees, 118 men and women, 114 men, 4 women are justices of the Supreme Court. Now, the power, how did they get there? Our Constitution provides in Article 2, Section 2, that it's the President of the United States who appoints members of the U.S. Supreme Court. But there are 2 significant limitations on that power that make it different than other presidential powers. From day one, a president can declare war, can sign executive orders, can send bills to Congress. But there are 2 limits on his powers to pick members of the Supreme Court. The first limit is he can only put members on the Supreme Court if there's a vacancy. That seems like an obvious limitation, but it's an important one. Not every president gets to fill seats on the Supreme Court. President Carter, for example, had no vacancies during his entire tenure as president, put no one on the Supreme Court. President Obama and President Clinton got to make picks in their first 2 years as president, but served 6 more years in both cases and didn't put anyone else on the Supreme Court. So the first limitation on the president's powers, there has to be a seat to fill. The president's kind of passive at the outset of this process, waiting around for a vacancy. The second limitation is also what's included in that constitutional text. The president's power to appoint is subject to the Senate offering its advice and consent. So the Senate has to, whatever that phrase means, but certainly means, has to weigh in and say yes before the president can appoint justices of the Supreme Court. Now, why is this an important power? Well, one reason is because of the duration of this choice. Justices of the Supreme Court serve for life, and that means that they serve for many years after their president picks them. Wesley mentioned that clerk for Justice White. He was put on the Supreme Court by President Kennedy in 1962, and 25 years later, I served as his law clerk. Justice White served on the court for 6 years after that, 30 years after President Kennedy's death. Justice White was still on the Supreme Court. So one reason why these choices are important is they really outlast a president. They are part of his legacy for not just years, but decades after the president serves. But the second reason these choices are important is because they are a president's way of changing our society, shaping our society. And I want to just offer 2 examples of that. Back in 1836, Andrew Jackson, a Southern a white nationalist president, put the man in the second box there, Roger Taney from Maryland, as Chief Justice of the Supreme Court. And 20 years after that, in 1857, Chief Justice Taney and his colleagues on the Supreme Court issued the Dred Scott decision, holding that African Americans could not be citizens under the Constitution of the United States. And that choice, the choice by Jackson of Taney writing the Dred Scott decision, was certainly one of the precipitating events of the American Civil War. And conversely, at the bottom of the screen, President Eisenhower in 1953 put Earl Warren, the former governor of California, as Chief Justice of the Supreme Court. And with Warren's judgment and political skills as a former governor, he brought the Supreme Court together and issued the unanimous decision in Brown versus the Board of Education, ending segregation in public schools and really kicking off the civil rights movement. So the president's exercise of this power can have sweeping ramifications for our country. as can the Senate's exercise of its role under the Constitution. And here are two examples of that from history. In 1969, President Nixon nominated first Clement and then Carswell. And the Senate rejected both of these nominees in 1969. Nixon's third choice was Harry Blackmun, a judge from Minnesota. 4 years later, it was Justice Blackmun who wrote the decision in Roe v. Wade legalizing abortion. A direct line from the Senate's action on these two nominations to a significant Supreme Court precedent. And more recently, in 1987, President Reagan nominated Robert Bork for the Supreme Court, a very conservative justice. He was voted down by the Senate. President Reagan nominated another Californian, Anthony Kennedy, to the Supreme Court. And just 2 years ago, Justice Kennedy wrote for the Supreme Court in the Obergefell decision that recognized marriage equality as a constitutional right. So both the President's role in this process, the Senate's role in this process, can have lasting implications and lasting consequences for our country. So I want to take a few minutes and talk about how this process works based on my experience working in it, as Wesley mentioned, and go kind of step by step through the process. And as Wesley mentioned, I've worked on 8 Supreme Court nominations, the nominations of these judges. First, the ones on the left as a staffer on Capitol Hill, the ones on the right as an advisor to both President Clinton and President Obama. And so that's kind of the experience I bring to bear on this topic. So as I said before, the process begins with the President waiting for a vacancy. And that's myself and Justice White back when I was a law clerk. And on March 17th, 1993, I was at my desk at the White House as an associate counsel to the President in charge of judicial selection, and the phone rang and it was Justice White. And he said, "Ron, why don't you come over for breakfast in 2 days? I'm going to have some of my former law clerks over, and you can come over for breakfast and we can catch up." And I thought, that was great. And I showed up for breakfast 2 days later on March 19th, 1993, and I walked into Justice White's office and there was no breakfast and there were no other clerks. There was just a big empty desk with an envelope in the middle of it. And Justice White said, "Hey, in this envelope is my letter of resignation from the Supreme Court. I want you to take this to President Clinton and tell him I'm resigning." And before I could say anything, he said, "Oh, and by the way, I'm making this public in 30 minutes, so you need to race back to the White House and get this to the President before it becomes public." Now, for those of you who don't know, Justice White was a great competitive individual. He is the only member of the Supreme Court to have been first in his class in Yale Law School and lead the NFL in rushing, an accomplishment all the more impressive because he did them both at the same time. He went to Yale during the week and played in the NFL on the weekend. And he still had that same competitive spirit back in 1993 when he challenged me to get back to the White House in 30 minutes with his letter before it became public. Now, today, of course, I would just hop on my cell phone, but of course in 1993 there were no cell phones, nor were there Ubers in 1993, and so I raced from the court back to my home, got in my car, drove swiftly to the White House, explained to the security guard why I needed to get in there, and that 2 minutes before 10 a.m. is me delivering Justice White's retirement letter to President Clinton, kicking off the process by which a president fills a vacancy on the Supreme Court. Then the president has to think hard about this choice and how he's going to make this choice and who he's going to put on the court. And it's a choice that almost always begins with something called the short list, a list that the staff has pulled together in advance of a vacancy, in the anticipation of a vacancy, for a president to consider. Who are the possible candidates that the president should consider? And in fact, the picture in the lower right is the day after Justice White's retirement. You see Vice President Gore there holding a piece of paper in his hand. That is the short list. That is the list we had prepared of potential candidates for the Supreme Court for President Clinton to consider when he made that first choice. Now, those of you who are fans of the TV show The West Wing know that this process of picking a justice was dramatized by an episode in season 1 called The Short List, which was loosely based on the process President Clinton went through in 1993, where he offered the Supreme Court vacancy to 7 different people, none of whom worked out, before he settled on the 8th person, who was Ruth Bader Ginsburg. And that kind of complete, long roller coaster process was very well dramatized by President Bartlett's choice in the first season of The West Wing, working off the short list that you see in Vice President Gore's hand there. But once the president starts to think and narrow the choice, then the vetting begins, the questioning of the nominee, the reading his or her writings, backgrounds, and material to try to understand how the nominee will do in the confirmation process, what the nominee said before that might be controversial, what the nominee's done before that might be problematic. And the picture right above that black and white picture is the very last meeting we had with President Obama just before he signed off on the vetting report, picked up the phone and called Sonia Sotomayor and told her that she would be his first choice for the Supreme Court in 2009. Once the president makes that choice, there's a lot of discussion about how that nominee is going to get confirmed, what kind of arguments the president's going to present, and how controversies in the nominee's background are going to be handled. And these are two meetings there on the left from the Kagan nomination with the president and his legislative affairs team, his political team, his press team, trying to figure out how to handle all that, how to roll out the nominee, and then ultimately, and then of course it ends with the happiest day of the entire confirmation process. In the early phase, the president makes his pick, and there you see 4 presidents standing there smiling as they announce they've picked these individuals to serve as their nominees to the Supreme Court. But of course that just starts a process. The nominee then is going to have to go up on Capitol Hill, going to have to present him or herself, going to have to win over senators to be confirmed. And that involves preparation and work with the team the president puts together to do that. Now, it's an interesting process. You have young lawyers preparing one of the most seasoned and accomplished jurists in the country for a confirmation process. Those jurists are highly confident in their point of view, highly confident in what they've done, and not necessarily that amenable to young White House staffers giving them advice on how to do that. And that was the case, of course, as you might imagine, when I was 31 years old in charge of getting Justice Ginsburg confirmed to the Supreme Court, a very determined person. And the practice wasn't going that well, the mock hearings weren't going that well, and we're kind of getting frustrated. We weren't really sure how she was going to do in these confirmation hearings. So a senior aide at the White House said, well, Ron, why don't you write up in a memo what's not going well and give it to a couple of senior people at the White House, and we'll go talk to her. And I remember thinking as I wrote this memo, I said to someone, well, will she ever see this memo, you know? And they said, oh, well, no, this is a highly confidential president document. It won't come out for 20 years. And I thought, well, I'm 31, 20 years, like 51. I guess I'll probably be dead by then. You know, like, why would I care about that? Oh, sure, fine, I'll just put it all out there. And so I wrote this memo in July of 1993 that said Justice Ginsburg performance pitfalls, and ended with the statement, and finally Justice Ginsburg's technique, her failure to make eye contact, her halting speech, her laconic nature is not helpful. And shared this with my senior colleagues at the White House in 1993, and really didn't think about it since then. She went on, by the way, to do extremely well in the hearings. It was all fine. And then in the summer of 2015, I got a phone call from the Clinton Library in Arkansas saying, hey, you know, we're about to release these really super secret memos that you wrote in 1993, and they're going to become public. And we just read one, and you just really dumped all over Justice Ginsburg in this memo, and like, it's going to be in the newspaper tomorrow, so you might want to like call her and tell her that this is going to be public. And so that was an interesting phone call. So in any event, the staff gets the nominees ready and prepares them for the hearing. And then, of course, the public weighs in. And the public weighs in a number of different respects. There are protests for and against the nominee, and certain public interest groups go out and do sometimes street protests. And they even dress up young people as the U.S. Constitution to engage in these protests. And some of those young people go on to become students at Claremont McKenna College. Even though they one day wore a mattress pad with the Constitution written on it as part of a protest. That was part of the controversy over Judge Garland not getting a hearing. And a group where my son worked at went around town and told people the Constitution said that he should get a hearing, and they demonstrated that by having people wear the Constitution as a costume. So in any event, leaving that aside, you do have these protests, these controversies, the public weighs in. This is a public process, there's no question about it. But ultimately, as I said before, it really comes down to the Senate making its decision. The Judiciary Committee hears the nominee testifies usually for 2 or 3 days, and ultimately the Senate committee votes, makes a decision whether or not to recommend the nominee to the Senate, and finally the Senate makes its decision and casts a vote up or down on members of the Supreme Court. And the process kind of ends. I love the fact that the whole process ends in some ways as the process began, with the president as a passive observer, with the president standing by and watching as a new member of the Supreme Court is sworn in, not by, of course, the president, but by the Chief Justice of the Supreme Court, and the president looks on, if it's gone well, with pride and joy. So that's kind of how the process works. What I want to talk about now is how the process has become dysfunctional in recent years and how the process has kind of fallen apart. How did the confirmation process become judicial wars, and what, if anything, can be done about it? Now look, the mere idea that the Senate would oppose judicial nominations for ideological reasons is not a controversial idea in of itself and not contrary to what the framers intended. And we know that because the framers themselves were in the middle of one of these controversies. That's John Adams, second president of the United States. Everyone should know that. On the far right, someone probably the lawyers in the room know, John Marshall, one of the great Chief Justices of the Supreme Court, the person who invented the idea of judicial review, the idea that the Supreme Court decides what laws are and are not constitutional. If you're a lawyer, you can't imagine a universe in which John Marshall is not Chief Justice of the U.S. Supreme Court. But in fact, the only reason the universe exists in which John Marshall is Chief Justice of the Supreme Court is because this guy, George Washington, nominated this guy, John Rutledge, to be Chief Justice of the Supreme Court. And the U.S. Senate voted him down on a 10-11 vote because of his controversial views on the peace treaty with Great Britain at the end of the Revolutionary War. So from the start, from the earliest days of our republic, the Senate's role in passing on nominations has included an ideological assessment of nominees, and the fact that the Senate exercised that power in rejecting the Rutledge nomination meant that Washington put kind of an older temporary person on the Supreme Court, Oliver Ellsworth, who passed away, giving Adams the chance to put John Marshall on as Chief Justice. So that fact, the fact that the Senate can be contentious, the Senate can oppose nominees, is not in and of itself an evidence of a broken process. But nonetheless, I do think right now we do have a broken process. So what makes that process broken? It's divided, it's polarized, it delegitimizes the federal courts, and you can see some examples of how controversial this has become. The last 4 justices, 2 Democrats and 2 Republicans, this is just a problem of one party or one president, drew more no votes than all but one confirmed justice since 1900. If you look at the 100 years of the 20th century, of 77 nominations, only 6 got more than 30 no votes. In the 17 years since 2000, 4 out of 5 have gotten more than 30 no votes. We had the spectacle of the Senate refusing to even give a hearing to Judge Garland's nomination, and the erosion of general guardrails that require bipartisanship in the process. The Senate going nuclear to confirm Justice Gorsuch, which followed the Senate going nuclear, getting rid of the filibuster to confirm judges for the lower courts under President Obama, and the recent decision by the Senate to get rid of the blue slip process, by which home state senators have a special say in the pick of judges from their states. So what are and aren't the causes of this kind of highly polarized, highly contentious process? Well, I think there are 5 possible explanations. I think there's truth in all 5 of these to some greater or lesser extent. The first is we just live in a general time of high polarization and high partisanship in our society. It's no surprise, as divided as we are as a country, as contentious as the political parties are, that has bled over into this process. Secondly, we're seeing an increasing mindset of win at any price in politics, and that's especially intense here, where the consequence is life tenure. It's hard to accept defeat on a nomination fight when the consequence is that someone's going to serve for 10, 20, 30 years. This isn't a temporary victory, it's a permanent victory that raises the stakes, that raises the contentiousness. Third, we're seeing the involvement of interest groups in the process like never before. The First time the National Rifle Association ever took a position on a Supreme Court nomination was on the Sotomayor nomination. We see groups on the left as well getting more involved. It's a more interest group-driven process, and that leads to some of this. Fourth, at a time of gridlock, when presidents are having trouble getting things done, their ability to put someone on the Supreme Court is a more significant accomplishment. It stands out. Wesley mentioned President Trump's nomination of Justice Gorsuch as something that stood out, for example, as one of his singular accomplishments in the first year of his presidency before he got the tax bill passed. So the significance of these picks to presidents is going up. And then finally, and I want to talk about this a little more, the court's recent involvement in political controversies tends to intensify the extent to which the court nomination process is more partisan, more political. Now, the process may be broken now. This is not the first time it's happened in our country. There are 3 other times when this has happened previously, where the process has gotten very contentious, very polarized. The first, not surprisingly, is around the Civil War and Reconstruction period. Virtually everything did. In fact, the Supreme Court at one point in time had 10 justices just before the start of the Civil War. It got down to 6 at the end of the Civil War because there's so many vacancies they couldn't fill. They finally settled on 9 in 1869. That's been the number ever since. But this was obviously a time of great contentiousness. That's not a surprise. There are 2 other times that are more relevant to our times. The first is the 1880s. It's an interesting period. It was a period of high partisan division, like our time now. It's also a period where the court intervened in a presidential election. In 1876, the presidential election was disputed, came down to a question of who had actually won the state of Florida, perhaps resonant with some of you from modern times. And the Supreme Court participated in a commission to resolve it on a 13-12 vote for one of the 2 candidates. And that kind of interjection by the court in partisan politics and the picking of a president kicked off a period where the nominees of both Democrat and Republican presidents were seen as highly controversial and often drew a significant number of votes. In fact, Justice Matthews got confirmed by only 1 vote in 1881, Justice Lamar by only 4 votes in 1888. And then the other period that I think the current period brings back is the 1930s, where just like today, the country was very divided around a lot of important legal issues. Back then, it was around the legitimacy of the New Deal and the effort by the Supreme Court to strike down many of the early laws passed on the New Deal. It led President Roosevelt to propose actually increasing the size of the court, adding more justices. Ultimately, that plan died because one of the justices switched sides. Justice Roberts went from opposing the New Deal legislation to upholding it in West Coast Hotel versus Parrish. And shortly after that, there were 2 retirements and let FDR remake the court. So we've seen this kind of dysfunction before, rarely, but at other times in our nation's history. Now, one thing that I think does not really explain it, that's often cited for the current bitterness, is the nomination of Robert Bork. A lot of people say that Judge Bork getting nominated and being defeated is kind of what kicked off the current bitterness. Yes, the Bork nomination certainly was contentious, but I think this theory really doesn't hold up when you look at what happened after Judge Bork's nomination. In fact, the 4 nominees after Bork, 2 Republicans and 2 Democrats, won overwhelming confirmation votes. Justice Kennedy, Justice Souter, Justice Ginsburg, Justice Breyer, all at or near 90-plus confirmation votes. So it's hard to draw a straight line between the fight over Bork and the current problems in the confirmation process, since the process worked well 4 times after the Bork nomination. In fact, it's really only after Bush v. Gore, after the Supreme Court repeated what happened in 1876, got involved in a controversial presidential election, really highlighted the court's role in partisan politics, that you've seen the troubles that followed. Chief Justice Roberts confirmed by a relatively narrow margin for a Chief Justice. Harriet Miers not even getting to the starting line. Justice Alito, again, more than 30 votes. That had happened only once in the previous century, followed by Sotomayor, Kagan, Garland not getting a vote, Gorsuch at 45. These are highly divisive confirmation battles. They're completely different than what we saw in the decades before, and even in the years between Bork and Bush v. Gore. So, can it be fixed? What can be done? I think the answer is yes, it can, if we all, as citizens, get together and demand some changes in this process. The first change is we need more consultation, less confrontation. You recall from the early slides, the Senate's role in this is supposed to be advice and consent. And presidents at different times in our history have taken the advice part of that very seriously, brought in senators, tried to consult with them, tried to find a middle ground, tried to find candidates that can be acceptable to both the president and the Senate. That kind of effort to find a bipartisan process to pick justices would certainly be a key step in the right direction. Secondly, more use of merit selection panels. This was a big movement in our country in the 1970s and the 1980s, to have distinguished groups of lawyers and judges and other lay professionals from both political parties come together and recommend candidates, particularly for the lower federal courts, but even for the Supreme Court. And taking some of the politics and partisanation out of it and replacing it with merit selection panels would definitely help the process. Third, we need better and more production confirmation hearings. If you watch the Gorsuch hearings, I thought they were kind of a mess in terms of the questions being confusing. It would make sense if the Judiciary Committee employed expert questioners, people who really knew the legal doctrine, to make the hearings more productive and allow the senators to make better choices about the candidates. And then fourth, I do think that we need a fixed timeline for hearings and votes on Supreme Court nominees. When the president exercises his power under Article 2, Section 2 to nominate someone, that person should get a vote. Again, up to the Senate whether that vote is up or down, but they should get a vote. What would a process that restored some of these guardrails look like? Well, we know because these guardrails used to exist, and there are 3 justices who were picked under processes that reflected this. John Paul Stevens was picked by President Ford. He hadn't been elected president. He was very conscious about how he would exercise this power. And he went to the American Bar Association and said, put together a list of the best lawyers in America. John Paul Stevens was on that list. He was President Ford's choice for the Supreme Court. Justice Ginsburg was picked in part because President Carter had a merit selection panel that put her on the Court of Appeals. She had that stamp of approval, that stamp of excellence from her career. That was one reason why she was on the list. And Justice Sotomayor is a really interesting case because she was actually put on the district court by a Republican president, again through a merit selection process. Again, another merit selection process put her on the Court of Appeals by President Clinton, leaving her available for President Obama to put her on the Supreme Court. Restoring these guardrails, I think, would be a good thing. It is an important process. As I said, it shapes our history, it shapes our culture, it shapes our society, it shapes our Constitution. It needs to be improved, and we as citizens need to be engaged to do that. So with that, I will stop and take your questions.
Thank you very much for your talk, Mr. Klain. We will now be taking questions. If you have a question, please raise your hand, and either Wesley or I will come and hand you the mic. Priority goes to students.
Hi, thanks for speaking with us. You said that one of the possible solutions would be an increased role for the Senate in consultation, and I'm wondering what you think the incentive for a Senate, especially if the majority is a different party than the president, to actually be constructive during this consultation process would be. One thing I'm reminded of is when Senator Orrin Hatch said after the death of Antonin Scalia, well, Obama could appoint a great Supreme Court justice like Merrick Garland, but there's no way he'll do that. He'll appoint some socialist. And then, of course, it was Merrick Garland, and Orrin Hatch and all the other Republicans refused to even vote for them. So in that kind of situation where there's a different party for the Senate than the president, why should we trust the Senate?
Well, look, I think 2 things. I mean, one, I actually think the Hatch example is a good story in the sense that it showed that President Obama was reaching out to Republicans in the Senate, trying to find common ground, and indeed pick someone who might not have been his first choice if he was just picking for himself, but someone who he thought could be acceptable to the Senate. The fact that it didn't work gets to a point I want to get to in a second, but I don't think necessarily that's a tale of why this shouldn't be done. In fact, I think it's a tale of why this should be done and needs to be carried a little bit farther. You know, another interesting example came when Lewis Powell resigned from the Supreme Court in 1987, and President Reagan put together a list of people and brought in Senate leaders, Democratic leaders. Democrats controlled the Senate at that time. Brought them in and said, here's the list of 10 people I'm considering. And Senator Biden, who was then chairman of the Judiciary Committee, Robert Byrd, who was then the Democratic leader in the Senate, said of these 10 people on the list, 9 of them are great. One of them is Robert Bork. Nominate him. You're going to have a huge fight on your hands. Nominate any of the other 9, they'll get confirmed. And President Reagan chose to reject that advice. Nominated Bork, had a huge fight on his hand, then proceeded to nominate the second person on the list, Anthony Kennedy. He got confirmed. And so, look, I think this dialogue is an important dialogue if both sides are willing to listen. And that's what needs to happen. And I think we've gotten to a point in time where hopefully both sides recognize the bitterness, the contentiousness, the divisiveness in this process, and hopefully we'll start to consider solutions. It's not going to happen overnight. We didn't get here overnight. We've gotten here over 17 years. But I think the dialogue itself is a step in the right direction, and I think if we had more of that dialogue, hopefully we'd get to more consensus and a little more cooperation. The thing that everyone has to know is that someday the shoe was on the other foot. The shoe was always on the other foot. There we have Republican presidents. Someday we'll have Democratic presidents again. We have Senates controlled by Democrats, Republicans. Someday it will flip again. So thinking about that, a little bit of institutional forbearance, a little bit of foresight, I think will help make these consultations productive in the future. Wesley.
Thank you so much for coming. You highlighted certain periods in U.S. history where in the past it has been equally contentious. Could you point out for us sort of what resolved the contention then, and then return it to a more sort of amendable process in the past?
Yeah, great question. So the ending of these prior periods of contentions were brought on by different events each time. The contentions of the 1880s were really resolved by a fundamental shift in our politics, the rise of the progressive movement, really transformation in the Republican Party in the late 1880s and the early 1900s, and a realignment between the two political parties that led to Republican presidents actually picking progressive justices for the Supreme Court. And that kind of got the process back in alignment between where the Senate Republicans were and where the president was, and the process went forward. In the 1930s, really it's a very interesting thing. There's a lot of historical controversy about what happened. President Roosevelt put forward his court packing plan. After that, Justice Roberts switched sides and went from being anti-New Deal to being pro-New Deal. The historic record kind of shows he actually cast that vote inside the Supreme Court before Roosevelt put his court packing plan on the table. So the idea that the court packing plan made Roberts change his mind is a very controversial idea. There's evidence, both ways, of course. But certainly what happened was the court itself changed. And then very shortly after that, 2 justices retired. Roosevelt got to pick justices, kind of realign the court in a different direction. I think we're in a different time now. I think a little more like the 1880s than the 1930s. And what we're going to have to see is how the political alignment post-Trump lines up, how the parties line up, and whether or not there's a sense after this highly contentious period in our history, and in our capital in particular, that people want more cooperation, more bipartisanship, and a little more return to normalcy in this process in particular. By the way, I'm also happy to answer questions about things other than the Supreme Court, if we want to talk about things other than the Supreme Court.
Yeah, well, I'm sorry, because my question's about the Supreme Court.
All right, well, no apology needed. I'm just...
Well, yeah, great talk also. Thank you for coming. So my question is, just based off of Will's answer, you said that part of the problem right now is that the president isn't communicating enough with party leaders when nominating Supreme Court justices. So what, in that case, since it's not really the Senate's fault, what went wrong when Obama nominated Garland? And was it Obama's fault? Was it the Senate's fault? Was it both their fault? Did they not communicate well?
Well, again, I think that was a case where President Obama and some Senate leaders communicated very well, and he picked a nominee who he thought would be acceptable to the Senate based on those communications. What went wrong there were kind of the other things on my slide. An election year that was highly contentious and partisan, the sense that the stakes of filling this seat, filling Justice Scalia's seat with a Democratic nominee, were life-tenure stakes in a winner-take-all time in our political system. The general level of division we have right now on certain legal and social issues. So I think none of these things work in the abstract or divorced from the general political environment in which we live in and the general political circumstance in which we live in. And certainly 2016 was about as harsh and divisive a year as you can imagine in American political life. Thank you.
Thank you for your speech tonight. I'm just wondering, after a career dealing with the judiciary, how did you leverage those skills to be head of Ebola Response team?
Yeah, it's a great question. I was sitting at my desk at my law job in mid-October of 2014 when the phone rang, and it was the president. And he said, look, Ron, I've got a job. And I was like, okay, sounds good. And he said, I want you to take over this Ebola response. And I said, well, you know, Mr. President, I'm not a doctor, not a scientist, not a general. I think if I do this, like, I'm going to get killed for doing this, and you're going to get killed for picking me. And President Obama said, look, I thought about that, and I think there are two ways this can come out. The first is, I think you can come in and do a really good job and save a lot of lives, and then no one will care what people say the day I picked you. And then the second is you could come in and do a lousy job, and a lot of people will die, and then no one will care what was said the day I picked you. So either way, it doesn't really matter what's said the day I pick you. And I said, well, that's, you know, it's kind of hard to argue with that. And so I agreed to come do it. And I think the reason President Obama asked me to come do it was not because I had any substantive background in epidemic response. I didn't. We had some of the best scientists and doctors in the world working on the Ebola response when I took over. Tony Fauci and Nancy Sullivan at NIH, Tom Frieden and Ann Schuchat at CDC, really leading doctors and experts in the field. But we had a government that wasn't working. We had agencies fighting. We had an inability to make policy decisions. We had a lack of prioritization. And the 2 years I had spent in President Obama's administration running the Recovery Act, implementing an $800 billion program that involved 17 federal agencies and had to coordinate between them, was the experience President Obama asked me to come bring to the Ebola response. Make the agencies work together, tee up issues for resolution quickly, cut to the bottom line, develop practical solutions. One of the problems we had at the time was that the system was kind of melted down with this reality. Thomas Eric Duncan, someone who had come to the United States from West Africa, had shown up unexpectedly in a hospital in Dallas with Ebola. He ultimately died from the disease. 2 nurses there got sick, and the country was paralyzed. There are 500,000 medical touch points in the country. How could you get all of them ready to deal with a potential Ebola patient? And so what we did in the Ebola response is we sat down and thought about the problem hard as a problem. And we came up with the insight that while there were 500,000 medical touch points in the country, there were only 2,000 people in the country who had been to West Africa within the incubation period, within the past 21 days. And so rather than getting all the touch points ready for a patient, we traced all the potential patients, gave them all cell phones with numbers to call if they felt sick, and checked in on them twice a day, every day, to make sure they weren't sick. And with a plan to take those 2,000 people to one of 50 specific facilities that were ready to test them and treat them if they turned out to have Ebola, right? We kind of turned the problem around from the medical touch points to the people. We set up the first process ever for screening people arriving to the country by rerouting air traffic to 5 airports where we could identify potential people coming from West Africa, use their travel records to really figure out who needed to be tested, screened, and monitored in the ensuing 21 days. We built up our capacity in hospitals here in the United States to treat people, looking at the data over where people from West Africa were coming and where the right hospitals were to match them with potential patients. And most importantly, we ramped up our response overseas. We built 17 Ebola treatment units in 45 days and had them open before the new year. We deployed experimental vaccines in West Africa. We did a lot of community training and education and really broke the disease. We went from having 1,000 cases a week in October in West Africa to under 5 a week by mid-February, and ultimately the disease burned out. So what I brought to it was some management experience and some problem-solving experience and some experience working with agencies. What I took from it was a tremendous interest in this problem. America faces a threat. The world faces a threat from infectious diseases, and we aren't prepared for that threat. 2018 is the 100th anniversary of the Spanish flu epidemic of 1918. It is the single largest death event in American history. Most people have never heard of it. More Americans died from Spanish flu in 1918 than died from World War I and World War II combined. 600,000 people died from the Spanish flu in this country in 1918, okay? You can't, there's one monument in this country to the Spanish flu epidemic in Pennsylvania. That's it, right? But we're at risk of something like that happening again today. The world isn't really prepared, and we need to invest in global health security to make sure that we're finding these infectious diseases overseas and helping people with their national health care systems track these diseases, respond to them, and control them locally before they spread around the world. And we need to do a better job of preparing our own hospitals and our own medical treatment facilities for these kinds of outbreaks in the future.
Hi, thank you for your talk. I was curious whether you think that in order to fix our broken confirmation process returning to the Supreme Court, whether senators would have to give up the litmus tests they've been using a lot in recent years on issues like abortion and campaign finance that are so central to what the Supreme Court does. Would they have to give those up in order for us to fix our process, really?
Well, I think that it's important to remember that the president is elected to pick a justice of the Supreme Court, but the senators are also elected to cast their judgment and their vote on confirming members of the Supreme Court. And I think what you have to find is people in the Venn diagram that fall between those overlapping circles of candidates acceptable to the president and acceptable to the Senate. And I think if both sides do that, I think there are potential nominees out there who fall in that category, who don't have to necessarily, senators don't have to necessarily give up their litmus tests. Senators don't necessarily have to, certainly shouldn't abandon their core constitutional principles and views. And I think you can find people who can meet those requirements and meet those criteria. Each senator is also a little bit different, and ultimately it's a game of getting to a majority, and hopefully more than a majority, closer back to the old days of a supermajority. I'm sure there'll always be some no votes on some nominees, even the ones in the period after Bork got 3, 7, 9, 12 no votes. I don't think we're ever going back to unanimous, but certainly I think we can find more consensus candidates who hopefully can satisfy both the ideological views of the Senate and the views of a president.
Thank you so much for your talk. What considerations did you and your colleagues make at the Senate Judiciary Committee when you were reviewing very conservative nominees, Scalia, Rehnquist, who were approved with overwhelming confirmation?
Yeah, I think I was a junior staffer on the Judiciary Committee during the Scalia nomination when Justice Rehnquist was elevated to be Chief Justice. He was a sitting Justice of the Supreme Court. Chief Justice Berger retired, and President Reagan nominated sitting Justice Rehnquist to become Chief Justice Rehnquist. It's very interesting. You see this often when there are two nominations at the same time, when a sitting justice becomes Chief Justice. The Senate coalesces around one of these two nominations. And in that case, it was very interesting. Though Justice Scalia probably was more conservative than Rehnquist, it was the Rehnquist nomination that wound up being the controversial nomination. There was a big effort to defeat Justice Rehnquist getting elevated to be Chief Justice. A lot of complicated issues around Justice Rehnquist. He'd actually been a senior official in the Justice Department during the Watergate mess, and people want to know, like, had he been involved in that? He was allegedly had harassed voters at a polling place in Arizona when he was in private practice. A lot of controversy around Rehnquist. And so I think what happened in that case was kind of all the chips went into the Rehnquist fight, and people kind of took a pass on the Scalia fight. And perhaps in retrospect, it was a mistake. Indeed, Vice President Biden has said the single biggest mistake he made in 30 years in the Senate was not thinking harder about the Scalia nomination, being a little distracted by the Rehnquist nomination. So I think that was, again, I think President has certain advantages in this process particularly when there are two nominees at the same time. Hard to get the attention span, Senate attention span, focused on both those nominees.
Hi, thanks so much for your talk. I'm sort of also asking about an area separate from the court, to an extent at least. How would you describe the office of the vice president based on your considerable experience, and how has it evolved?
Yeah. So there's an old joke about vice presidents. Mother had two sons, one went off to sea, one became vice president, neither was heard from ever again. Thomas R. Marshall, great vice president, once said the vice presidency is not worth a warm bucket of spit. So look, historically, the role of the vice president has been basically to sit and wait for the president to die. And that's not much of a job, really, and that's why most people who've been vice president have hated the job, because that's kind of been a nothing job. That really changed with Vice President Mondale. Vice President Mondale worked out an arrangement with President Carter to be an active member of the president's team. He was the first vice president to have an office in the West Wing. Before Vice President Mondale, vice presidents didn't have an office at the White House. Think about how hard it is to be influential if you don't even have an office in the building. Vice President Mondale was the first one to have an office in the White House. Vice President Mondale was a member of the National Security Council. He was a close advisor to President Carter. They didn't agree all the time. They had different political perspectives, but he certainly was a significant player in the Carter administration. And that set a precedent that each vice president after that and each president after that have followed. All the subsequent vice presidents have had offices in the White House, have had weekly meetings with the president, access to the president, access to key meetings. And the president and the vice president really decide how that's going to work and how the vice president's role is going to play out. I think that role has become even more significant in recent years as our government gets more and more complicated and problems get more and more complicated and acquire an aspect of interdisciplinary nature that make it hard for cabinet secretaries by themselves to solve problems, and they need coordination. And the president can't coordinate everything all the time, so recent presidents have used vice presidents often to coordinate among the agencies and to solve hard and complicated problems. So I think in addition to this kind of relationship thing that started with Mondale, there are structural reasons that have elevated the office of the vice presidency and have made vice presidents more significant players in recent years. And certainly Vice President Biden was very influential with President Obama. Vice President Cheney, very significant with President Bush. It's hard to understand exactly how the relationship between President Trump and Vice President Pence works right now. We tend to learn these things really after the fact. But again, it seems like Mike Pence is a pretty consequential vice president, has a lot of impact around certain issues, certain kinds of policy things. Some vice presidents really focus on particular policy issues. When I worked for Vice President Gore, he really spent most of his time working on the environment, and science and technology is his real specialty, his real focus. We took a really lead in the administration. Vice President Biden, who I worked for, was more interested in being an all-around advisor to President Obama. But there's certainly it's become a more significant job. The one thing that the job still is no good for is for becoming president. It's the biggest misconception we have in the American political system, that vice presidents is a stepping stone to being president. There's only one sitting vice president since 1824 who has been elected president of the United States, George H.W. Bush in 1988. So it is not a great stepping stone for becoming president, but it is a very significant role in our government, and certainly one that's grown in significance in recent years.
Thank you so much for your presentation, your education, the enlightenment, and the long history of our Supreme Court. Could you give us a little glimpse of the present and the future? Are there any potential retirees on our current Supreme Court? If the Senate stays in the next 2 years, as they're predicting, and the President as well, we have 3 more years of a Trump presidency and possibly 4 beyond. So what is the makeup of the court, possible retirees? Also, what will be the big issues that will come before the court in the next 2, 3, 4 years that are working their way up through the system that will have an impact on the country?
Great questions. So first of all, the Supreme Court is made up of old people. You know, and that means, and I mean no disrespect or ill will to any of them, but sooner or later all of them will go, and you know, probably more sooner for some than others. Justice Kennedy has been rumored to be considering retiring, contemplating retiring, and it's thought that President Trump's pick of Neil Gorsuch, who had been a law clerk for Justice Kennedy, was seen as a bit of an olive branch to Justice Kennedy, an effort to induce him to retire by picking one of his former law clerks to serve on the Supreme Court. Now, this is a great guessing game. Justices never show their hands, as I illustrated with the story I told about Justice White surprising me with his retirement. So no one really knows. One thing people look at is are the justices hiring law clerks for future years? But the justices have gotten smart to this, and they always hire law clerks for future years and figure these talented young people will find a job somehow, even if they retire, which is not a bad guess. So Justice Kennedy has hired law clerks for several more years. Justice Ginsburg has hired law clerks for several more years. But whether or not one or both would retire, we just don't know. We certainly know that they are both advanced in age, and you know, sooner or later this will happen, right? I think clearly, as we saw with Justice Gorsuch, we will see contentious fights in the current political alignment of a very, very closely divided Senate. We're going to see what happens in 2018. Right now, the Senate is 51 to 49. It's hard to get much closer than that. And obviously, President Trump's a highly controversial president. And so I think if Justice Kennedy retires, particularly this year at the end of the court's term in June, which is kind of a common time for justices to retire, though not always, we would see a big fight over whether or not President Trump will get his person nominated and confirmed before the 2018 election, when the control of the Senate could flip potentially. But I think guessing who's going to go, when they're going to go, it's like a super duper hard thing to do, and I wouldn't even want to venture a guess at it.
Hi, thank you so much for your talk. I'm wondering if you can offer some predictions or just your expertise on the issue of abortion as it approaches any kind of interaction with the Supreme Court, especially given Gorsuch's opinions on the issue and the high level of political or public involvement with the topic.
Yeah, I think there's no question that so much of this issue, so much of the public controversy around the court does center around the issue of abortion. It's the one issue that I think the public is most engaged with on both sides of the question, and the one thing that drives the most voters who vote on the Supreme Court on both sides of the question. Certainly, as Wesley alluded to in his introduction, a factor that drove conservatives who might otherwise have had objections to Donald Trump to support Trump on the idea that he would nominate justices who would reverse Roe v. Wade to the Supreme Court. In fact, I think it's a little more complicated than that. What the Supreme Court has shown over the past decade and a half is efforts by the conservative justices to clip away at the abortion right without necessarily overturning Roe versus Wade, to uphold more and more restrictions on a woman's right to choose, to allow waiting periods, to allow different kinds of state interventions, limitations on when an abortion can be had, different kinds of regulations of abortion clinics. And these have been kind of the major state initiatives that have come to the Supreme Court and been upheld by a more conservative majority on the court. And so I think that's probably the most likely direction we would see if the court got even more conservative, is not so much necessarily a frontal assault on overturning Roe v. Wade altogether, but really an increasing number of restrictions. This has had the practical effect in many states, making abortion very difficult to get, very expensive, very few providers willing to do it. But I think that's probably the most likely direction you'd see if President Trump got more people on the Supreme Court. Also, the other thing I should say about this in general, back to the question that was asked before, is that these replacements aren't, kind of just like random draft picks for random seats. Obviously, one reason why Republicans fought so hard against the Garland nomination was that Judge Garland, a kind of moderate progressive, was going to take the seat of the court's most conservative member, Justice Scalia, and have a big impact on the balance of the court. When George Gorsuch replaced Justice Scalia, it really didn't have much impact on the ideological balance on the court. We replaced one conservative with another. So part of how these fights play out is a bit of what seat we're talking about. If something happened and Justice Thomas retired tomorrow, and President Trump nominated a very conservative person to replace Justice Thomas, that really wouldn't have much impact on the direction of the court. On the other hand, if Justice Ginsburg got ill or stepped down and President Trump replaced her, that would have a big impact. So part of the answer to all these questions turns a little bit on what seat we're talking about President replacing as that vacancy occurs.
You spoke earlier about the role of the public and how important it is for the public to voice its opinion. Now, a week ago, we have this tragedy in Florida, and the public students at the school there's really been a groundswell of protest about current laws. History says that these protests fade after time and nothing really changes. Do you see any impact on this for the current issue?
Yeah, I mean, nothing has been more vexing in my 30 years of working in politics and policy than the issue of gun control. When I was chief counsel of the Judiciary Committee, we talked tonight mostly about my work on judicial nominations, but it was also when the Senate first passed the first ban on the assault weapons, first passed the Senate in 1990, was ultimately enacted in 1994, and the Brady Bill, the first background check law, that again first passed the Senate in 1991, and ultimately was enacted in 1994. And those were super hard fights 20 years ago, narrowly won by advocates for gun control, and put in place a 10-year ban on assault weapons that expired in 2004 and was not renewed, unfortunately. And a background check process that, though has kept 3 million guns out of the hands of people who failed background checks, still has a lot of loopholes that have allowed people who shouldn't have guns to get guns. After Newtown and the horrible tragedy there, people thought that we were going to see a return to some of this action. And you had the bipartisan effort led by Senator Manchin, very conservative Democrat from West Virginia, Senator Toomey, Republican from Pennsylvania, come together with a background check proposal. And surely with those two senators coming together from different sides of the aisle, surely we could get action, and yet we didn't. Now, I think the question is it different this time? And certainly I hope and pray that it is. And certainly there are some signs that it are. I saw the president today put out a statement saying he would consider additional background check legislation. I think that there's a lot of pressure on Republican senators from Florida even to do something about this. Maybe it will change. But what I do know is that in the end, we got this done in 1990 and 1994 because the voters who were tired of the level of crime we had at that time in our country outnumbered the voters who stood with the NRA to oppose that kind of legislation. And if we've hit a point in time like that again, I think ultimately the system will respond and we'll see some common sense measures. But I think obviously it remains to be seen if that's where we are as a society and as a country and as a political system.
Hi, I was wondering if you could give us any insight you have about the 5-4 vote a couple of years ago on the immigration issue of deferred action for parents of Americans, and also what you see coming for any future issues that might percolate up, like DACA and the president's travel ban.
Yeah, so just to be clear, the vote on President Obama's executive order to provide status to the parents of Dreamers was actually a tied vote at the Supreme Court. One justice recused. It was a 4-4 vote. And because of that, like every sport has its rules, here's a weird Supreme Court rule. If the vote is tied, the decision below stands. So maybe that's not such a weird rule, but it is a little bit of, it seems kind of almost happenstance, right? Like there are all kinds of appellate courts over America. If one side wins the appellate court, they can get a tie. That becomes the law of the land. And that's what happened with that. It was a 4-4 tie that left in place a decision that struck down from the Fifth Circuit, a Court of Appeals that struck down President Obama's executive order in that regard. We still really don't know what the Supreme Court would do if you had a case that involved all 9 justices. And certainly we don't know what the Supreme Court would do if the DACA itself ultimately winds up being litigated, which may well be what we see here if the Congress doesn't take action to regularize the status of the Dreamers in the ensuing few weeks we have. Will state attorneys general, as they've threatened, sue to invalidate the DACA program? If they do, what will the courts hold? And if they do, that will, of course, go to the Supreme Court. And in this case, all 9 justices would participate in that case, and we'll finally get a ruling on that program. So I think this is, in all likelihood, coming in our future, maybe even coming in 2018. More likely, though, probably not coming from the Supreme Court until 2019.
Unfortunately, that is all the time that we have this evening. Please join me one more time in thanking Ron Klain.
Thank you.